appeal in the matter of the King on the application of Ariyo and London Borough of Richmond upon Thames.
Yes, Mr. Streeton.
Yes, my lords, I appear for the appellant, the London Borough of Richmond on Thames. My learned friends, Mr. Parkinson and Mr. McKay, appear for the respondent, Mr. Ariyo. In terms of housekeeping, in addition to the core supplementary and authorities bundles, I'm hoping you've received an applications bundle.
Yes.
And so in terms of the order of play, I propose to deal with those applications as preliminary issues, then to make submissions in support of my grounds of appeal, dealing firstly with the permission construction issue, and then secondly with the alternative argument, and then finally to address my submissions on the response.
I don't think there's any objection to your supplementary skeleton argument.
Well, not to the supplementary skeleton itself, and I'm not even clear on the alternative request for the admission of the evidence, but I obviously object.
I think there's no objection to looking at the premises licence.
Yes.
Which, as far as I know, is the only additional evidence you want to adduce.
Yes, my lord, it is.
Yeah, right. Well, you can.
But there is my objection to learned friend's argument.
Well, it's a very late objection. The question of noise was certainly raised by Dr. Ariyo as one of his main objections to the application. The question of noise was raised in the JR claim form and in the skeleton argument before Mr. Ockelton. If it's a new point, it's absolutely at the margins. It doesn't require evidence, and we are going to allow the respondents to argue their respondents' notice points.
I'm grateful, my lord. I'll turn then simply to deal with the substantive issues.
Yes.
And of those, as I say, I propose first to address the construction of the 2005 permission, and then secondly to make my alternative arguments on why the Deputy Judge was wrong in any event.
Yeah, you can take it that we've read the judgment, we've read the skeleton arguments, and we've read the officer's report and decision.
I'm grateful. I'll turn then to deal with the construction of the 2005 permission, which is in my skeleton of paragraphs 43 to 48.
Yeah.
And if you'll notice in the judgment below, paragraphs 23 to 28. That's pages 88 to 89 of the core bundle. And my essential submission is that the permission granted by the 2005 consent extended to the rear garden. And if I'm right about that, then subject to the second and third issues in the respondent's notice, I say that this appeal should be allowed regardless of the other issues before you. In terms of an approach to the 2005 permission, I'd like first to look at the legal principles, then to look at the permission in context, and finally to make my submissions on it. So on the legal principles, my lord, if we could have out the decision of the Supreme Court in DB Symmetry, Authorities Bundle tab 25, page 485, paragraph 66 in the judgment of Lord Hodge.
Before we dive into the cases, I should also mention that we have to rise at 4:15 or by 4:15 sharp today.
Understood, my lord.
Right, DB Symmetry.
DB Symmetry, paragraph 66, that's tab 25, page 485 of the Authorities.
Yeah.
And my lord, from that, 2 points. Firstly, that there are no special rules in relation to the interpretations of planning permissions. They're to be interpreted in a manner similar to any other public document, asking what the reasonable reader would understand. But secondly, that the reasonable reader is to be treated as being equipped with some knowledge of planning law and practice. Yeah. It's in that context that I'd like to emphasise 3 related principles of planning law and practice, of which I say a reasonable reader would be aware. The first is the relevance of the red line on the application plan. The second is the concept of the planning unit. And the third is the relevance of ancillary status and the use classes order. So dealing with the first of those and the relevance of the red line boundary, if we could go back 1 tab in the Authorities, please, to the Supreme Court's judgment in Hillside. Tab 24 of the Authorities, and it's paragraph 27 that I'd like to look at on page 441 of the Authorities bundle.
Yeah.
2 points from that, my lord. Firstly, that the meaning is to be ascertained from the document itself and other public documents to which it refers. And secondly, and you see this at the bottom of the paragraph just going over the page, that the plans submitted with the application have a particular significance, and then there's a cross-reference to the judgments in the case of Barnett.
Yeah.
And it's the case of Barnett that I'd like to turn to next, if I may, which is tab 12 of the Authorities bundle. That's the Court of Appeal's judgment.
We don't have the application itself. We only have
We don't.
some
No.
Has that just disappeared?
I think yes is the answer. We have what's on the file. So page 152,
Sorry, what tab was that?
tab 12, the judgment of the Court of Appeal in Barnet, to which that paragraph of Hillside Cross referred. My submission is that this case is authority for the proposition that where planning permission is granted for a material change of use, the extent of the area over which that new use is permitted is taken generally to be defined by the red line on the site plan. That's my proposition. And to make that good, I would just like to spend a moment with this authority, if I may. The court, as we'll see from the head note at H2, was concerned with the interpretation of two permissions in that case. One was for the erection of a dwelling granted in 1995, and the other, just at the bottom of page 152, was for the extension of that dwelling granted in 1998. And the court held that the permission granting the erection of the dwelling included an implied consent under section 75(3) for a change of use, and therefore the change of use was across the whole of that area, but the extension application contained no application for a change of use and so didn't change the use within the red line area on the plan. For the ratio, if we could go to paragraph 18 in the judgment, please, which is page 158. I'd just ask my lords to note there the reference to what was then, and indeed at the time that the 2005 permission was granted, was still Regulation 3 of the Town and Country Planning Applications Regulations 1988. The text of that regulation is in the first instance judgment in Barnet at page 144 of the authorities, paragraph 19. I don't think we need to turn it up, but what it includes is a requirement on any application that the application shall include the particulars specified in the form and be accompanied by a plan which identifies the land to which it relates. And so that was that regulation, and that was the reliance being placed on it at paragraph 18 by the Court of Appeal, cross referring to the first instance judgment. If we then go forward to paragraph 24, you see in the first 3 lines that there was agreement that the 1995 Commission had established the curtilage of the dwelling that became the manor. And the issue was then about the effect of the extension permission. Paragraph 26, we again see reference to the 1988 regulations, Regulation 3(1)(b), and the terms of the application. And then the meat of the judgment in my submission begins at paragraph 29. And if we could just pause, and I pause paragraph 29, the first 3 lines of that paragraph set out what the question was in the view of Lord Justice Keane, and he says the principal question, which he, like the inspector, had to answer, he being Mr. Justice Sullivan, was whether the 1998 Commission granted planning permission for ancillary residential uses for the additional land within the site plan red line beyond the 1995 curtilage. That's what he says was the issue. Then in the second part of that paragraph, the next 4 lines, he says that as a convenient shorthand that was referred to as extending the curtilage, and that on the facts of that case it was appropriate to treat them as amounting to the same in practice. And then the third point is that he says the judge, Mr. Justice Sullivan, recognised that when permission is granted for a new dwelling, the dwelling house will normally have a curtilage including uses such as a garden, possibly a driveway, and that will normally be identified on the site plan. If we go over the page, his reasoning in relation to that specifically refers to the implied application as a result of section 75(3), and I might just ask my lords to read to themselves to the end of paragraph 29.
Yeah.
What does he mean by normally be ascertained by reference to the site as defined?
I think
in
it could be
the site plan?
displaced by clear wording. So if on the face of the permission it said the change of use shall only be for this part of the site, then the fact that the application plan had gone beyond that, I don't think would displace the clear wording on the face of the permission. And it's open to an authority to cut down an application made to them.
Yeah.
Well, the final point to make on this authority is that the distinction drawn then with reference to the 1998 permission, and we see that most clearly from the second half of paragraph 31. It's 7th line down, 2 words from the end starting what however. What however seems to me to resolve the matter quite clearly is the application form and the permission itself. Neither of those documents refers to any proposed change of use of any land. The application form states that it is an application for alteration or addition to an existing dwelling. The box required to be completed for a change of use is left blank, and so the subsequent blocks where in change of use applications the existing use has to be stated. The planning permission itself contains no reference to any change of use of land, but it's simply permission for an extension. So that, I say, was the key distinction. Where the application doesn't include an application to change use, the red line boundary doesn't contain an implicit change of use consent. But where you have an application to change use, the red line boundary is assumed to be the area over which the change of use is permitted. That, I say, is the effect of Regulation 3.1b as it then was in the 1988 regulations. So that's my first point that a reasonable reader would be aware of. The second relates to the planning unit. This is dealt with in my skeleton at paragraphs 32 to 40. And the planning unit, as my lords will know, is the area over which the materiality of a change of use is to be judged. If we could just have open Authorities Bundle tab 17, starting on page 264, it's paragraph 54 in the judgment KPJR management.
Yeah, this is going back to Birdle.
It goes back to Birdle precisely, and it's just because all of the authorities are conveniently separate in this case, but Birdle is the leading case, and we have Birdle set out at paragraph 54. The points arising from Birdle, as I'm sure the court is familiar, is that the starting point is the unit of occupation, is that where it is possible to identify a single main purpose to which secondary activities are ancillary or incidental, the whole unit of occupation should be considered. But that where within a single unit of occupation, 2 or more physically separate and distinct areas are used for different purposes, each area should be treated as separate planning units. And that's a conjunctive test. There needs to be physical and functional separation. So that is the established approach in Birdle. The third point then I'd like to deal with are ancillary uses and the use classes order. You'll note that's my skeleton paragraphs 32 to 33. My lords, planning control permits the fluctuation of uses within a planning unit by focusing on the primary use rather than uses which are ancillary or ordinarily incidental. And where the primary use falls within a use class order, then the use is governed by the effect of that order. That order was made pursuant to section 55(2)(f) of the Town and Country Planning Act, which for your note is behind Authorities Bundle tab 2, paragraph 7 to 8. I would just like, if I may, to look at the decision in Brooks and Burton, which dealt with the effect of the use classes order. That's tab 4 of the Authorities Bundle. And in my submission, so it's page 36, in my submission, Brooks and Burton is authority for the proposition that intensification within a use class does not result in a material change of use. My lords will see from the head note on page 36 that the case concerned intensification of the use of land for manufacturing concrete blocks, and that there had been a considerable increase in the intensity of that use, more than 4 times the number of blocks being produced on the site. Enforcement action was taken on the basis of intensification, and the enforcement notice was upheld both by the inspector and the divisional court, but the Court of Appeal overturned those decisions below. The ratio is summarised in the report at page 1295 F2H, and the judgment is the judgment of Lord Justice Lawton that we're concerned with. That's within the report 1305 C to D, and if we could just go there, please, that's page 47 of the authorities bundle.
Sorry, page what?
47 of the authorities.
Yeah.
And it's at letters C to D that the court recognises the relevance of land occupied together with land used for a purpose within the use classes order. And then over the page, the sideline section on page 48 makes clear that any use within a use class is exempt from planning control regardless of the intensity of the use. And you'll see from letters C to D on that page, as long as the company can find their operations on the site to class 4 use, they're entitled to the benefit of section 22 2F as it then was.
I'm lost. Where
I
are
do
you?
apologise. So page 48,
Yeah.
letters C to D,
C to D, yes.
last
Right.
3 lines of the first paragraph. And then 4 lines below letter D, having regard to what we judge to be the right construction of Article 2.3, it matters not whether the intensification of use found by the inspector to have taken place did amount to material change of use, provided it was within the class. And that is because
So it's not that it doesn't amount to a material change of use, but that even if it does, it doesn't matter.
it's not development. And perhaps it would just be helpful to then look at section 55 2F of the Primary Act.
Just a minute. I think we may have a temporal mismatch, maybe not. This point would arise if the grant of planning permission in 2006 had allowed the permitted use to be changed as regards the rear area. If the permitted use, if the lawful use of the rear area was not use ancillary to the restaurant, then this principle wouldn't apply, would it?
I think there are 2 points to make about that. The first is that it would, provided it's, and that was the point I was making with reference to page 47, provided it's owned and used together with the building, and they specifically reject a test of ancillary status. You'll see that at letter D on page 47.
So wait a minute. So you say, is this how you put it? You say that if as a matter of construction, the planning permission only applied to the ground floor of the built envelope, then the incorporation of the rear garden, if I can call it that, into restaurant use was itself permitted by the use classes order. Is that the way you put it?
That is one of the 3 ways I put it, yes. So
I followed the first 2.
yes. Well, I think there's one further way, which is that use as a shop is within the same use class as use as a restaurant.
Now.
So now.
Yeah.
And at the time that the permission challenged was granted, but not in 2005. And so if, as the Deputy Judge seems to suggest, it continued in shop use, if that remained its lawful use, then in 2020 it could be put to restaurant use because of the change to Class C of the use class.
So that wasn't the officer's reasoning.
No, it wasn't the officer's reasoning. He thought it's all in use class EB, it's all in restaurant use.
Well, yes, I'm not sure he went into the use class. He just said it's long-standing.
No, he did go into the use class. I can deal with that when we get to it. He specifically says it's in use class EB. But my point here is that when you construe the permission, the person granting the permission will understand how the use classes order works, and they will know that land owned together with the building is expected to be in the same use class as the building. And I'll come to this, but I say it's rather uncomfortable to have this odd plot of land apparently left in commercial use, and that will be a point on the construction. But at this stage, I'm just dealing with that as as a point in terms of understanding.
Yeah.
Just to deal with my Lord Justice Males's point about the effect of this. So it's by operation of statute. Tab 2 of the authorities, page 7 to 8, it's section 55. The linchpin of planning control is the concept of development. And what the statute does in section 55 2F is to deem any change of use within the use classes order, or within a single class of the use classes order, to be out with the scope of development and therefore out with the scope of planning control.
Yes, no, well, I only mentioned it because your earlier point was that you cited this case to show that the intensification within a use class does not amount to material change of use, and it seemed to me that it was more accurate that what this case says is that it doesn't matter whether it amounts to a material change of use so long as it's within the same use class.
Yeah, it's not development, it would have been a better way to put it, my lord. Lord, the final point on the law that I'd like to make before I turn to the facts and the construction of the 2005 permission is in the case of Fiddler, Authorities Bundle, tab 8, page 100, 99 going over to 100, the judgment of Lord Justice Carnworth, and it's proposition 4 in his paragraph 28, which is that the use classes order cannot apply to a composite use. So where you have a reference to a use class, that can only be for a single planning unit.
Yeah.
So those are the principles with which I say the reasonable reader would be familiar, and I turn to address the construction of the 2005 permission. I propose to do that by looking firstly at the primary documents, then making my submissions in support of my construction, and finally explaining why I say the judge is wrong.
Yeah.
So the primary documents, if we could start with the local authority's decision notice, which is in the supplementary bundle, tab 5, page 22. This refers to the plans, so the recital starting whereas refers to the illustrated plans, and we see from over the page 23, in the informative, the drawings include the OS extract, that is the site location plan we'll see. And the nature of the change of use is from one use class to another, A1 hardware store to A3 restaurant. We then look at the plans, and if we go back one tab to tab 4, we have the site location plan. So that is the plan submitted pursuant to Regulation 3.2 of the 1988 regulations, as they then were. And I would just like on that plan, if I may, to point out, firstly, as is obvious, that the red line area covers the whole of the site, including the rear garden. Secondly, you'll see there's a building at the rear of that plot. That is the garage building, which we'll see referred to later. And thirdly, to the north of the site, directly adjacent to the north to number 206, there's an access road which goes to an area at the back, which is the parking area we'll see referred to later.
And what's the significance of the blue lines, if any?
The blue lines are land owned by the applicant and in his control. So if you make an application for planning permission, you have to show what nearby land you own as well.
And the access road that's coming off the road, which is, so to speak, almost at right angles to the terrace.
Yes. So you have the red line, then the blue line, then a gap between the blue lines and another blue line. It's the gap between the two.
Oh, I see.
That goes to that area at the back next to the garage. That's how you get to the garage. You drive down there.
Okay.
And that will become relevant when we see the decision letter. Final document I'd like to look at before the decision letter itself is the layout plan. And in my submission, what we clearly see here are two physically and functionally separate units. On the first floor, with its own separate ground floor entranceway, is a residential flat. And on the ground floor is a restaurant comprised of a seating area at the front, a kitchen at the back, lavatories to the rear and left, and with 2 accesses to the rear garden, one through the kitchen and one through the fire exit. And those are the only accesses into the garden in this direction. You can go through the garage or you can go this way.
Yeah.
And I do say, and I'll make this good later, but in my submission, on any rational view, those are 2 planning units. There's no other way to properly construe it. And indeed, when we look at the decision letter, we'll see that they were 2 planning units before. So if we turn to the decision letter now, that's tab 6 of the supplemental bundle. The heading cross-refers back to the application, and my lords will see in the final bullet point before summary of decision, again, reference to 2 different use classes, A1 to A3. So shop to restaurant.
Yeah.
And as I said with reference to fiddler, those have to be, well, that has to be a single planning unit. Otherwise the use classes order can't apply, and the inspector will be well aware of that. If we then, within the decision, look at paragraph.
Does it refer to change of use of the ground floor?
It does, yes.
No, why does it?
Well, because it's distinguishing the first floor, which is already separately in use as a residential dwelling. So it's not suggesting there's any change of use of the first floor. And in my submission, ground floor includes the ground floor garden. As I said, we'll see that from the substance of the decision letter. So within the decision letter, if we could start with paragraph 4, please. Let's start with the words, the ground floor of the appeal premises is currently in use as a hardware shop. It also includes a kitchen and self-contained entrance. And then that goes on, in the area to the rear, there is a polytunnel where plants are grown for sale in the shop. Now, I just pause there.
So is it accurate to say it's a change of use of the ground floor from a general hardware store to a restaurant if the flat kitchen was also on the ground floor?
Well, my lord, I think probably it would continue to be inaccurate in the sense that the access to the flat is to this day on the ground floor. So whether or not you move the kitchen, you're allowed internally to reconfigure. The point is that the change of use is of an area in A1 use to an area in A3 use.
Yeah.
And I think probably it's not something that people worried about, to be completely honest, at the time, because it was perfectly clear from the layout plan what was proposed.
Yes.
But the point that I wanted to make was that right up front, paragraph 4, when describing the premises, there is reference to the area at the rear, and that being where plants are grown for sale in the shop. So it's well understood by the inspector that that area is being used together with the shop for a purpose ancillary to the shop's use, namely the growing of plants for sale.
Yeah.
And paragraph 6 reinforces the same point, where it says, about halfway through, notwithstanding the appellant's attempts to support his business by growing plants for sale in the shop, is evidence relating to viability. And it goes on to say it's not viable to run a shop of that nature there. So again, the inspector is predicating her understanding upon the garden and the shop being a single unit used together. That she thinks that that will continue following the grant of permission, i.e. that the restaurant will continue to incorporate that garden area, is, I say, clear from paragraph 9 of the decision letter. And my lords, if you could just read the first 2 sentences of paragraph 9.
Yeah.
So, my lords, the inspector is clearly anticipating that staff working in the restaurant will park in the garage at the rear of the garden area within the red line boundary. It makes no sense in my submission to suggest she didn't understand that she was granting planning permission for that to be used ancillary to the restaurant. What did she think she was granting permission for? It's simply irreconcilable with that statement in my submission to exclude it.
So, I mean, your point here is that it wouldn't make any sense to have ground floor use limited to the restaurant, ancillary use limited to the garage, and some indeterminate shop use
Between the
between.
two. Yes, and where one is seeking to make an application for planning permission which relates to a very specific area, then you can draw your red line boundary accordingly. We do actually have the example of that with reference to the case in question. So if we just keep a finger in where we are, but look at tab 15, page 81, which is the application plan in this case.
Yeah.
You'll see you can dice it like that. But that isn't what was done in this case. That I say, paragraph 9 is obviously cross-referring to what's referred above in paragraph 8 about the disturbance from staff being confined to the premises. So I do say the whole decision is predicated upon an understanding that that plan will involve a change of use. And then paragraph 11, which is the formal decision, says that the permission is granted in accordance with the terms of the application and the plan submitted herewith. So applying regulation 3.2 of the 1988 regulations, the change of use is across the area on the plan submitted, and that is the natural and ordinary meaning of it. And to return to the point my Lord Justice Moylan made, there are no clear words excluding that. On the contrary, everything is consistent with it.
Yeah.
Before I leave this decision letter, I just want to deal with the point that the Deputy Judge made about paragraph 8 and the conditions, because he says that it cuts across the entire meaning of this permission to extend to the rear garden, because there's a condition requiring, or there's a suggestion that there will be a condition which isn't actually imposed, of a condition requiring insulation. But I just asked my lords to note the difference in the wording relating to extraction and ventilation, which is in the 2nd, 3rd and 4th lines, which refer to the amenities of surrounding residents.
Yeah.
And the wording in relation to the proposed condition for sound insulation, which is about 5 lines from the bottom. I agree that a condition requiring sound insulation between the proposed restaurant and the residential accommodation above is necessary. So it's not about general residential amenity, it's specifically about noise travelling through the floor, and that's why it's proposed to put insulation in there. And that's got nothing to do with the rear garden. And it certainly doesn't cut across that for the inspector to have thought she was permitting ancillary use of the rear garden. So to make my submissions on the construction of this consent, I say that the judge was wrong to conclude that the material change of use permitted by the 2005 permission did not extend to the rear garden. On the proper construction of that permission, it did. Firstly, because that is the effect of Regulation 3 of the 1988 regulations as applied in Barnet. Secondly,
Those were the regulations still in force, were they, in 2005?
yes, still in force in 2005. A materially identical regulation is now in the Development Management Procedure Order.
Right. And if we want the text of that, you say it's in the first instance.
It's in the
decision
first instance judgment of Barnet, paragraph 19.
Yeah.
Secondly, it's consistent with the language of the decision letter read as a whole, which refers throughout to the use of the rear garden as part of the current A1 shop use, and therefore must assume that that is the planning unit at that time, granting change of use to a different use class A3 across the same land. Secondly, because it specifically envisages the use of the garage at the rear of the premises being used ancillary to the restaurant. And thirdly, because it expressly grants permission in accordance with the plans.
You took us to paragraph 8. If you look at the last sentence of paragraph 8, it says any disturbance from staff is likely to be confined to the premises.
Yes.
What premises are they being referred to?
In my submission, the rear garden and within the restaurant itself. So they would be moving to and from their vehicles parked in the garage, and then they would be within the restaurant, perhaps talking or tidying up, sweeping up, and then returning to their vehicle.
There is access to the garage from the garden, is there?
Yes. So my third point is that that's consistent with the layout shown on the layout plan, which identifies 2 physically and functionally separate units of occupation, 1 the flat above and 2 the whole of the ground floor, with a shop and garden owned together and accessible from one another. And my fourth and final point is that it avoids absurdity, the point my Lord Justice Lewison made to me. If the planning permission doesn't change the use of the garden to a restaurant, well, what is its effect? The respondent has never answered that, and the judge seemed to think it remained in shop use, but in my submission that makes absolutely no sense in the absence of a shop, and that it cannot, on any rational view, have been a separate planning unit in commercial use, albeit that it would in any event ultimately have ended up in Class E. So those are my positive submissions on the construction of the permission.
Yep.
To deal with what the Deputy Judge said against me, and this is my scout in paragraph 47, I've already dealt with the point about cutting across with reference to soundproofing in condition 8. The second point is the point my Lord Justice Moylan made to me about the meaning of the ground floor. In my submission, the ground floor includes the garden because it's a ground floor garden. It's not a roof garden, for example. And you often get ground floor flats with gardens. I think it's my submission on the ground floor.
You wouldn't normally speak of the garden as being the ground floor. You might say it's ground level.
Yes, my Lord, I see that, but I say it's certainly not inconsistent with the wording of the permission.
That's a different point, but
It's not unnatural. I think that's the way I would put it. It's not unnatural.
Yeah.
My third point is that there's nothing in the argument that the red line covers the first floor flat 2. Again, partly a point my Lord Justice Lewison made to me that there's the access area on the ground floor in any event. But also of necessity, where you have a multi-storey building, the location plan will always include the upper storeys. You can't draw it any other way. But were it intended to confine the change of use simply to the ground floor of the building, I say the red line would have been around the ground floor of the building. See by comparison, page 81. And then fourthly and finally on this, I say that the judge's approach in his judgment at paragraph 26 and then 33 to 36 suggests something of a misunderstanding of the approach to ancillary uses in the use classes order. Particularly paragraph 33
just a minute.
of the judge's judgment, it might be helpful to have that. So that's the core bundle, tab 10, page 91. And it's the last 3 lines where the judge refers to the lack of access from the restaurant area to the garden before and after the structural alterations. And what he means there, I think, is the restaurant as opposed to the kitchen or fire escape. And in my submission, that's just a complete misunderstanding of how ancillary uses work.
Yes, I mean, I would have thought that really your point is that the judge considered the question of the planning unit in the wrong place. He had come to the conclusion in paragraph 28 that the planning permission applied only to the ground floor of the building. And then he asked himself whether there's some means by which the permission carried permission to use a larger space, rather than looking at the principle of the planning unit in deciding whether the planning permission was restricted to the ground floor.
Yes, my Lord, I agree. It's a logically prior question. But even when he comes to do that exercise, he seems not fully to understand that the restaurant use washes across the whole of the restaurant, not just the bit in which people sit and eat. So the kitchen is of necessity ancillary to the restaurant. I mean, otherwise you would have kitchen uses all over the country, which you don't. Similarly, moving on within his judgment, paragraphs 35 to 36, he refers to the effect of section 55 to F and the use classes order, but in my submission misunderstands the man, doesn't apply Brooks and Burton, which was cited to him. What we have here is one use class A1 and then a second use class A3. And had he understood it properly in that way, he couldn't have reached the decision he did. In any event, the construction of the permission is a matter of law for this court. But I do say he approached it in the wrong way. So for all those reasons, my submission is that the use of the land for Class C is lawful pursuant to the 2005 permission, and the officer was in no way wrong in reaching that conclusion himself.
So, as you say, it's a question of law,
Yes.
but at paragraphs 4 and 5 of your skeleton, you assert in very absolutist terms that whether or not a use is lawful is a matter of planning judgment. Now, I know you refer to section 1912, but a use or may be immune from enforcement because it's within a planning permission, or because permission's being granted by a GDO, or because it's not development at all, because it's within the use class. And those are all questions of law, aren't they?
Not everything that my lord has just said is a question of law, but it's a.
I mean, some questions will be questions of planning judgment. Is this ordinarily incidental to the use of a dwelling house? Well, okay, matter of planning judgment. Is this within the terms of a planning permission? Would, as you say, be a matter of law.
Yeah.
And if you wanted to know, was the use lawful because of the existence of a planning permission, that's not a matter of planning judgment.
It's a mixed question of fact and law. You have to properly interpret the permission and then ask yourself whether the use falls within the scope of the permission. The latter is a planning judgment, the former is a question of law. I think that the way that I have put it is too absolutist, to use my lord's terms. But what I mean is that questions such as the planning unit and the nature of the use over time are questions of planning judgment, and in my submission the judge went beyond the scope of his role.
The judge, you say, was also too absolutist, but in the
Yes, I do.
It's a bit more nuanced.
And it is more nuanced than that, and I have always accepted that the construction of the permission was a question of law, and I said that to the judge at first instance.
Yeah.
And I dealt with things the other way round from him. So I said, what does the permission mean? Which is what I'm doing in this court as well, because that is the primary question, and if I win on that, frankly, nothing else really matters.
Yeah.
And then there's a secondary question, even if I'm wrong about that, what was the position lawfully? And I say the second of those questions is much more a question of judgment. So perhaps I could turn to address that second question. My submission is that even if I'm wrong on the construction of the 2005 permission, officers made no legal error in concluding that the use was lawful and long-standing. I was going to go to the officer's report later, and I would like to come back to it later, but just to make one point now, because my lord said, or suggested earlier, that the officer didn't address the use classes order. He does. It's page 227 of the call bundle, where he describes the site. So under heading 2, perhaps my lords could just read those 2.5 lines.
Sorry, which paragraph?
It's under heading 2, description of the site and its surroundings.
Right.
Yes, I'm sorry. What I meant was he didn't justify his conclusion that the use was lawful, use of the garden area was lawful, by reference to the use classes. He didn't say, well, even if I'm wrong about the planning permission, it's all permitted because it's all within Class E. He didn't say that.
No, absolutely not.
And he didn't say, I interpret the planning permission to include the rear area.
No, but he plainly did.
So that's all I meant.
I quite understand that, my lord. I think the point that I would like to make, and this perhaps goes to the second of the points my lord just made, how he interpreted the planning permission, is that the officer does, in my submission, clearly identify 2 distinct planning units.
Yeah.
So he says the ground floor and rear garden of the site is currently in use as Class E B restaurant. So he says that's one planning unit within a use class. And then the first floor is use Class C3 dwelling house. So that's another use within use class order. And I mean, it is worth just contextually remembering that what he's dealing with is an application for planning permission for a building within the garden. It's not an enforcement case. This is contextual description. And so you perhaps wouldn't expect a detailed level of analysis, provided he appropriately applies his mind to the issue, which I say you see him doing there. But I accept that amongst the points that I propose to make are points which the officer did not himself address his mind to, and that goes to section 31(2)(a) rather than directly to the lawfulness of the decision. To make my submission good, I propose to look at the primary documents after the 2005 consent, then the test of lawfulness, and finally to make my submissions. So on the primary documents, if we could have the supplemental bundle out, please, and go behind tab 10 to the 2008 permission. Page 43 refers in the recital to being illustrated on the plans. And if we then go to those plans, which are behind tab 8, we see that the site layout in 2008 very much includes the garden area. That's on the site plan, page 30.
Sorry, which page?
Page 30, tab 8.
Can I just ask before we go there, why is the application for a change of use from A1 when permission had been granted earlier for use A3? A1 had stopped by then, hadn't it?
So I think the proposal was to amend the existing permission, and that's probably why it's been put in that way. And we can see that from page 31, amendment to existing permission. I mean, it does there say A3 to A3 and A5, but I wonder if the local authority thought, well, if it's supposed to be an amendment, then what we're changing is the shop to a mixed use.
Right, so we're looking at the plan.
But I want to look at the plan behind tab 8, page 30. And it's on the right-hand side of that plan. Clearly shows the whole area, including the demolished garage and the proposed garage. Very much includes the garden area. Now, I quite accept this was a temporary permission, and it ceased to have effect after a year, and we revert to the 2005 permission, and that's why what matters is the 2005 permission. But bearing in mind that, as we just saw with reference to page 31, this was understood to be an amendment to that previous permission. That was clearly the basis upon which it was understood at the time, and more importantly, was the basis upon which the owners of the site were working. So they were using it ancillary to their restaurant, assuming that that's what they had permission to do from 2005.
Yeah.
Indeed, everyone was working on that basis. So it's not just a jury point, it's an evidential point as to what continued to happen on the site. If we then look at the decision challenged in detail, and there isn't too much to say about it, so that was back in the core bundle, tab 18, page 227. In fact, if we look on page 226 first, there is a long and detailed description of the planning history. So the officer has clearly been back through the file and considered the records, and it's broken down between development management, appeals, building control decisions and enforcement. But in reaching his judgment, the officer has quite clearly gone carefully through the file and set it all out. He says that he's done that under the introduction, second paragraph, for preparing a summary report. The planning officer considered any relevant previous planning applications. And then we have the point that I already made with reference to section 2. If we go over the page 228 to 229, just so that I don't have to come back to it later, we'll see in section 6, before that, at the top of page 228, there's a summary of the objections, and there's a specific reference to an objection on the grounds of noise. Then at the bottom, section 6, explanation of officer recommendation, sets out the previous decision making, including at the top of page 229, third paragraph, italicised, the appellants have attempted. What I say is the key reasoning of the inspector in her decision letter, and I'll come back to the detail of that.
Yes.
Then, next paragraph deals with LP8, and the last sentence recognises the potential from harm from various impacts, including noise, air pollution, odours and vibration.
Is that the officer's word or his paraphrase of LP8?
This is paraphrase of LP8, I think.
That paragraph's just setting out what LP8 says.
Yes, it's setting out what might be relevant to LP8.
Yeah.
And then in the next paragraph, he goes on to deal specifically with noise. And his analysis of noise can be parsed as follows. Firstly, the use is currently long-standing and lawful. And I do emphasise the use of the word long-standing, because he's not just said it's in accordance with the permission. He's also said it's been going on since 2005, 2008, essentially. That's what I say that means.
Yeah.
So he works on that basis. He then says, consequently, issues associated with this use, such as noise or parking, are not in question, i.e. the principle of that use is already established over this land. And then thirdly, he goes on to address what, if anything, needs to be done about noise. And he says, mitigation of noise disturbance is secured by existing planning conditions. Any breaches of conditions, such as operating hours, should be dealt with separately. So he clearly does understand that those conditions apply. I accept that that is the basis upon which he is working.
And the only relevant condition is the condition that limits the operating hours of the restaurant.
Yes. And so in my submission, his judgment, as ascertained from this paragraph, is that provided the hours are limited, there's not an unacceptable impact on noise. And I say that's a perfectly legitimate planning judgment to take. And I'll come back to the detail of it in response to the
Well, the
point.
previous officer said there wasn't an acoustic assessment and it was quite impossible to decide whether or not there would be noise problems arising from this structure, rather misleadingly called a pergola.
Yes. But, my lord, doesn't
Now
go...
you've shown us the premises licence, which says they can play live music until late at night and recorded music even later. One would have thought that having a permanent structure with retractable glass panels hard up against the boundary wall was not at all the same thing.
When you say not at all the same thing, you mean...
As this garden area being ancillary to use of the restaurant.
Well, you can play the music outside pursuant to the licence. So...
What's the point of doing that in the winter when there's nobody sitting out there?
No, well, I mean, I'm not saying you necessarily would play it outside. I'm also not saying you necessarily would play it outside now because, of course, the licensing regime is one issue and you can review the licence at any time if there's disturbance to neighbours. And secondly, there's the nuisance regime. And we can see in the context of the 2008 officers' report that officers specifically say there are other regimes which control issues related to noise. So I think that the fact that there is a premises licence including live music, which I think is also deregulated now, canned music and alcohol until 11 p.m, I say is entirely of a piece with the approach taken here. And just to be clear, because my Lord Justice Lewison referred me to the previous officer's report, it ended up not being a reason for refusal in the previous decision.
No, because it was focused on the visual aspects of the structure.
Well, not just that it was focused upon, that was the only reason upon which the council relied. And to be clear, the council is under a statutory duty pursuant to the Development Management Procedure Order to give its full reasons, including all relevant policy, when it refuses an application and to include those in the statutory reason for refusal. So that was the reason, and it was only the reason that was given, and I'll come on to that in the context of the consistency point. But my Lord, my submission at this point is simply that that was the judgment reached, and that it falls well within the scope of a reasonable planning judgment, bearing in mind the ambit for such judgment. I don't think, my Lord, in light of the discussion I've already had with you, I need to address the court on the approach to the legality of a decision on lawfulness. Questions as to the scope of the planning unit or the materiality of a change of use are questions of judgment. Questions as to the construction of documents and the scope of legal powers are matters of law. So I turn then to make my submissions. Firstly, dealing with the planning unit, that's my skeleton at 62 to 66.
Well, I think you've already covered that, haven't you?
Yes, my Lord, I think probably my Lords have the point on that, and I've already submitted that it was the only rational view available. Secondly, on immunity from enforcement, I say it was clear, and this is my skeleton paragraph 60, it was clear from the 2008 permission that the garden was used together with the restaurant since at least that time. There was nothing to suggest any dissociation of use subsequent to that. And the judge's approach at paragraph 37 of the judgment below is to rely on the photographs in the supplementary bundle, tab 2, page 38. I'm happy to go there. If my lords have seen them already, we don't need to.
Yes, I mean, your point here is the judge went into an area which is fact-finding.
Exactly, he went into a fact-finding area, and in doing so, he didn't seem to recognise the concept of an ancillary use. So I say the council were entitled to reach the conclusion they did, and then finally on Class C, I say even if it remained in commercial use, well, that was still Class E, and so the finding that it was Class EB was unlikely to be different, even if the judge was right about what he said, which I say he certainly wasn't. So for all those reasons, I say that the conclusion that the use was lawful and long-standing was legally impeccable. Turn then to deal with the points in the respondent's notice. There are 3 of them.
Can just before we go there,
Yes.
policy LP8, as paraphrased by the officer,
Yes.
says that development must protect the amenity, etc., of neighbouring occupants, and it goes on to say design must avoid noise. Now, where in this decision did the officer consider whether the design of this particular structure was such as to avoid noise?
The design was such as to avoid noise.
Yes.
I don't think he looked at it in that way.
No, shouldn't he have done? If he was going to come to the conclusion that the proposed development satisfied LP8, shouldn't he have looked at how it was designed? He might have said, for example, well, you can't have retractable glass panels, or glass must be triple glazed, or something else. We don't know.
I don't think he was required to address the issue in that way. And I think that would be to put a straitjacket on his officer's report, entirely contrary to Mansell and Faber and Maxwell. And it's not a point that has been taken against me to date, so I don't have an immediate answer to it because I haven't addressed my mind to it. But it seems to me that he was entitled to do it in the way that he did, which was to look at the principle of the use, and then having looked at the principle of the use, to conclude that the conditions which existed relating to hours were sufficient. Essentially, I think, because it's in a row of commercial shops, and yes, there's some noise, but it's going to stop by a reasonable hour. That was the view the officer took, and that was his planning judgment. And he was entitled to do that. I haven't even got the text of LP8, I don't think, in front of me or in the bundle. And if I were to deal with it, I would certainly want to have the text of the policy in front of me before I responded to my lord's question. So my lord, I turn to deal with the points in the respondent's notice. Firstly, on the applicability of conditions, I mean, I entirely accept, as will be apparent from my submissions, that the officer's approach was predicated upon the understanding that the conditions on the 2005 consent applied to the garden area, and that if the use wasn't pursuant to consent, that was wrong. Completely accept that. But in response to that, I say, firstly, that in practice, it is difficult to see how that would work because the indoor area could not be open to customers after 11 p.m. And so there would have to be some sort of bifurcation of the premises where people are outside afterwards. I say in practice, that just doesn't make sense and certainly doesn't seem to be what anyone's suggesting is happening. And secondly, the premises are in any event subject to control under other legislative regimes, including the licensing regime. My lords will see from the supplementary bundle, tab 9, page 35 in the 2008 report, paragraph 35.
Sorry, isn't it?
Sorry.
Supplementary bundle, tab
9,
9.
page 35.
Yeah. Yes.
Paragraph 8, dealing with noise and disturbance. This was in the context of the takeaway application.
Yes.
That the council, last line, specifically relies on control under other legislation.
Mm-hmm.
And in this instance, my lords have seen the premises licence. That controls regulated activities, licensable activities, defined in section 1 of the Licensing Act 2003, to include the provision of late night refreshment. That's defined in Schedule 2 of the 2003 Act, which is in the Applications Bundle, tab 6, page 52, to include the supply of hot food after 11 p.m. And the licence doesn't include any licence for late night refreshments, so they can't serve food after 11. Similarly, the term allow for all licensable activities.
Sorry, just a minute. Where in the licence is that?
So it's not in the licence, it's in the legislation.
Oh, I see.
My lord, if you go tab 6 of the Applications Bundle, section 1 of the Licensing Act 2003, licensable activities, and then there are 4 of them.
Late night refreshment.
The last one, and then that's defined in Schedule 2, page 52 of this bundle, after 11 and before 5.
Yeah.
And then when we go to the licence, it's not there, so if you look on page 22, it's alcohol, music and recorded music. There's no late night refreshment licence. So that would be under the licensable activities if it were licensed.
Yeah.
So food not licensed after 11. Terminal allow for all other licensable activities is 11 p.m. or earlier. Opening under the licence is until 11:30, but that obviously doesn't change the planning permission, which is until 11. And so overall, I do say that this is a point which is highly likely not to have made any difference, because the licence covers the lot, and the judgment was predicated on the hours in the condition. And so it wouldn't have made a material difference, and section 31(2)(a) applies. I don't know that I need to address my lords on the substance of section 31(2)(a) and the way to apply it, but for your note, the law is set out in the case of Gather Coal at paragraphs 36 to 39.
Gather coal.
Gather Coal, it's a judgment of Lord Justice Coulson. It's tab 22, pages 398 to 400. It quotes the judgment of this court in Goring upon Thames, which makes clear the duty applies to substantive errors. And that what the court must do is undertake an objective assessment. So that was tab 22.
Yep.
Pages 398 to 400.
Yeah.
And it cites the judgment of the Master of the Rolls in Goring, paragraphs 47 and 55 of that judgment, which make the point that it applies to substantive errors, and that what the court must do, this is Goring, paragraph 55, is undertake its own objective assessment of what the result of the decision-making process would have been.
Sorry, where are you reading from?
So, on page 398 of the bundle,
Yes.
the court quotes the judgment in Goring upon Thames.
Yes.
And within Goring upon Thames, paragraph 47,
Yeah.
letter D,
Letter D. Right. Thank you.
I apologise. The concept of conduct is a broad one, apt to include substantive decisions and the procedural steps. And then paragraph 55, the next quoted paragraph.
Yeah.
If, however, the court is to consider whether a particular outcome is highly likely not to have been substantially different, it must necessarily undertake its own objective assessment of the decision-making process, what its result would have been if the decision-maker had not erred in law. And then over the page 400, paragraph 38 in the judgment of Lord Justice Coulson. This court makes clear that it is important that the court doesn't shirk that obligation.
Yeah.
And that the provision is designed to ensure that even if there was a flaw in the decision-making process, which might render the decision unlawful, where the other circumstances mean the quashing would be a waste of time and public money, the decision must not be quashed and the application must instead be rejected. In that way, judicial review remains flexible and realistic.
Yeah.
And I say that once you apply those principles to the facts that I've set out, the position is that section 31(2)(a) applies.
Yes.
Turn then to deal with the second point in the respondent's notice, which is the alleged failure to have regard to noise impacts. That's the supplemental skeleton, paragraphs 11 to 19. My short answer to that is that the council did not fail to have regard to the potential for noise impacts upon the claimant. As we saw, for your note, Core Bundle tab 18, page 228, the respondent's objection on noise grounds was set out and summarised, so officers had clearly read it, understood it and referred to it in their report. And then over the page 229, a recognition that harm may arise from various impacts such as noise, and a paragraph specifically considering that issue, but forming the view, as I said, that it's not in breach of planning control and that mitigation is adequately secured by condition. Very much, I say, a planning judgment. And my learned friend's criticisms of that approach, I say, are just the sort of legalism this court has repeatedly deprecated. What is put in the report in terms of detail was for officers, and it certainly wasn't irrational for them to do it in the way that they did. Final issue then is consistency. And I have two essential submissions in response to the point on consistency. The first is that the inconsistency asserted by the respondent is illusory on a fair reading of the 2022 decision letter. And the second is that regardless, the 2022 decision letter's conclusions were taken into account and reasons given enabling the reader to understand what was decided and why. On the legal principles, perhaps you might just turn those up. It's Authorities Bundle, tab 20, page 325, the judgment of this court in Bates and Moylan, paragraph 19.
Which tab is that?
Tab 20, starting on page 324. And Lord Justice Hickenbottom helpfully summarises at paragraph 19 the principles, of which I identified to your Lords Roman 2, 3, 4, 7 and 8. And just to expand upon what I said, the most important of those, in Roman 3, the court is clear that consistency is not a principle of law, and that when considering it, one has to consider whether the case is distinguishable, and then ultimately it is all a matter for the decision maker to exercise his own judgment. And then with reference to 7 and 8, reasoning is the South Buck standard, and there's one point I want to touch on with reference to that. And in terms of differing from an earlier decision, that applies where the difference is on a crucial planning issue. And even then, the standard of reasoning, I say, is still the South Buck standard. Just on the South Buck's standard, my lord, if we could look very briefly at South Buck's, not at paragraph 36, which is the summary paragraph, but at paragraph 34, it's Authorities Bundle, tab 7. And it's page 81. And I'm sure my lords are familiar with this decision. Paragraph 36 is the off-quoted summary of the law on reasons in a planning decision-making context. That essentially is a summary of the law which was set out before that, and in particular paragraph 34 refers to the case of Bolton. I just asked my lords, it's at letters G to the end of the page, to read the excerpt of the quote from Lord Lloyd of Berwick's speech, which goes over the page, page 82. You don't need to refer to everything, and an inference that something wasn't properly understood or considered will only be drawn where all known facts and circumstances point to that conclusion. And again, in answer to the point my Lord Justice Lewison was making to me about LP8, there's certainly no strong positive contraindication or overwhelming circumstance that suggests a misunderstanding of LPA. It may well be that the officer did consider the nature of the structure. The point's not been taken, I haven't got instructions on that.
Yeah.
Applying that to the facts, my lord, if we could look at the 2022 officer's report first, so not the decision report, but the refusal report. That's in the supplemental bundle, tab 11, page 52.
Yes.
And I know my lords have read this. The position previously taken, as my Lord Justice Lewison said, was that in the absence of an acoustic assessment, it wasn't clear what the impact would be, but that ultimately the commercial use, so it's under noise, second paragraph, the commercial use of this rear garden area is lawful in planning terms and associated noise connected with the land use, whether open and enclosed cannot be raised as a material reason for refusal in this case. So they took the view that it wasn't a reason to refuse on that case.
Sorry, where's that?
Sorry, page 52 behind tab 11, under the heading noise, second paragraph, starting the commercial use.
The recommendation also refers to the lack of clarity on the noise disturbance, although it doesn't find its way into the refusal itself.
It doesn't, and as I said, my lord, earlier, Article 35(1)(b) of the Development Management Procedure Order requires the full reasons for refusal to be given, and that is a statutory statement of reasons. That then takes us to the decision letter, tab 13. And my submission, as I've said, is that the inconsistency my learned friend relies upon, in fact, is illusory. If we could start within the decision letter at paragraph 7 and work through it. So this is page 61 of the bundle.
Yeah.
Paragraph 7 does not refer to noise within LP8. It exerts only the section of that policy which says the council will ensure that proposals are not visually intrusive or have an overbearing impact as a result of their height, massing or sighting. No reference to noise. And I say that's unsurprising given the reason for refusal. Paragraph 8 then refers to windows and overlooking the pergola structure, i.e. the visual intrusive and overbearing impact of the structure, what you can see from those upper windows. Paragraph 9 is the paragraph my learned friend relies upon, and it makes no mention of noise whatsoever. Rather, it refers to the difference in the prospect of the lawful use, which the inspector doesn't question, as against, as she puts it, the prospect of the creation of a permanent large enclosed structure to facilitate year-round usage by restaurant guests. So what she's talking about is what you see out of your window, not what you hear in your house. And that makes perfect sense in the context of LP8, which she's referred to already, and the fact that she's referred one paragraph previously to the view from the windows. Then paragraph 10 deals with the attempt to mitigate that overbearing visual impact and includes a conclusion. Overall, this is the last 3 lines, I consider the scale of the reduced structure would not significantly improve the poor outlook of the substantial structure from neighbouring residential rear windows.
Yeah.
So it's all about outlook. It's not about noise at all. That feeds into her overall conclusion, which refers to 2 things, overbearing impact and visual intrusion. In short, on any fair reading of this decision letter, it doesn't say anything about noise. That then feeds into my submission, because my learned friend's point is that the council ought to have recognised an inconsistency with this and explained it away. But on noise, there is no inconsistency with this because it doesn't say anything about noise. Where there is the risk of an inconsistency, the point is dealt with. So if we could look at the officer's report, please.
These are the decision, impugned decision report.
The impugned decision report.
Yep.
So that's tab 18, page 229.
Yeah.
Under visual amenity, 2 paragraphs on the bottom starting while the materials, and about 2/3 of the way through, it says it should be acknowledged that the pergola would still be visible from the upper windows of neighbouring properties. This was a concern of the planning inspector, which has to be taken into account. The additional planting along the boundary would significantly improve their outlook compared with the existing structure. As such, the proposal is felt to have responded sufficiently to this issue. So on the point made by the inspector, there is just the sort of reasoning that you would expect there to be in an officer's report, complying with that duty that we saw enunciated in Bates and Moylan, stemming from the North Wiltshire case.
Yeah.
In the absence of an inconsistency on noise, more did not need to be said about that point. In any event, this is my final submission, my lord, noise was, I say, adequately dealt with for the reasons I've already given. And adding another sentence to refer to the inspector's paragraph 9, and I genuinely don't know how that should have been framed, but adding a sentence to that would not have made a difference to the outcome. And the officer had obviously considered what the inspector had to say, taken it into account, and he reached his own judgment. That was what he was entitled to do.
Yeah.
So, my lords, unless I can be of further assistance, those are my submissions.
Thank you very much, Mr. Streeton. Yes, Mr. Parkinson.
Thank you, my lord. I'll start by setting out the structure of my submissions. So first I'm going to deal with the correct interpretation of the 2005 permission, and our simple submission is that the judge was correct to find it didn't extend in geographic scope to the garden, not least because the description of development referred to a change of use of the ground floor of the property. Secondly, I'm then going to address the 2 alternative routes by which the appellant contends that the garden had a lawful restaurant use. So by virtue of Class E or by virtue of Section 171B. Read in context, we say the judge clearly appreciated that the question of whether a use was lawful under those routes was a mixed question of fact and law, that provided the right legal question was asked, the factual determination made by the council is ultimately a matter for them. The judge's essential reasoning was that the council and the officer hadn't asked the questions necessary to determine whether the use of the garden was lawful under either of those routes, which of course is an established public law error. And that was the basis for why the judge rejected those 2 alternative routes to lawfulness, that the council hadn't considered them and hadn't asked themselves the questions that they would need to ask in order to reach a lawful determination. And of course, we say in any event, in reliance on the first respondent's notice point, it doesn't matter if the judge did err in how he approached those 2 alternative routes, because if the use of the garden was lawful under either Class E or Section 171B, the conditions attached to the 2005 permission wouldn't apply to the garden, and the officer, certainly in the second officer's report, proceeded on the basis that they did. So that's that, in a sense, deals with the first half of my length friend submissions. Then I'm going to deal with the 2 other respondents' notice points. And of course, those proceed on the basis that the council was entitled to find that the use of the garden as a restaurant was lawful by either of those routes. And the simple point that underlies both respondents' notice points, but in particular the second, is that the officer proceeds on the basis that because the use of the garden for restaurant purposes was lawful, the noise impacts arising from the pergola or the gazebo were not capable of being taken into account as a reason for refusing planning permission. And obviously I'll go through this exercise, but one has to trace through the first officer's report, which led to the refusal, and then read the second in the context of that. And the first is very clear. We say that the officer says this is a matter that cannot be a reason for refusal, not should not, but the noise arising from the pergola cannot, which explains why it's referred to in the recommendation, but not the actual reason for refusal. And my lords, if you're with us on that, we say that that's a clear error, because the additional noise created by the pergola was certainly capable of being a material consideration for the council to take into account, regardless of the underlying lawful use of the garden, for the simple reason that having a large enclosed covered seating area with retractable roof facilitates a year-round use of the garden for outdoor dining, whereas without that structure being there, one's reliant on the British weather for whether you can sit outside and eat or not. So there was clearly a potential for increased noise disturbance brought about by the pergola, and the council erred in taking the view that they could not take that into account.
But can you read across what the first officer said into what the second officer said?
Well, my lord, I'll go through that exercise. I say that we can.
Yeah.
The reasoning is similar. The language is slightly different in the second report, but it's, we say, making the same point, that because the use is lawful, the impacts associated with the pergola, the noise impacts in particular, can't be taken into account. And then, of course, I'll deal with the Senior Courts Act point at the end. So if I can start off with the 2005 permission, and there's no dispute as to the legal framework. The court has to ask itself what a reasonable reader would understand the permission to be granting, having regard to the natural and ordinary meaning of the words, read in context, and having regard to common sense. And that comes from DV Symmetry and Trump and the passages my learned friend took you to. And I'm proposed to deal with this under 4 headings. So first, the description of development, then the approved plans, then the conditions attached to the permission, and then finally the appellant's absurdity or common sense arguments. It wouldn't make sense to sever the restaurant from the garden area. So the starting point is the description of development, and that is set out at paragraph 11 of the appeal decision, which is tab 6 of the supplementary bundle, page 26. And I would suggest that of all the factors that can be taken into account in interpreting a planning permission, this is probably the most important, because it's a description of the development that is being permitted. And it's quite clear that what the inspector has granted planning permission for is for the change of use of the ground floor from a general hardware store to a restaurant at 208 Hampton Road. And that tells us in terms what the geographic scope of the permission is. It's a change of use of the ground floor. And a reasonable reader would understand that the ground floor is the floor of a building at ground level. That's how any reasonable reader coming across this would understand that to mean. Ground floor means the ground floor of a building. But to the extent that there's any ambiguity in that, the inspector herself defines what she understands ground floor to mean. And we can see that at paragraph 4 of the decision on page 24. Because she says, the ground floor of the premises is currently in use as a hardware shop, but also includes the kitchen and self-contained entrance to the flat on the upper floor. So that's what the inspector understood ground floor to mean. She then distinguishes that from what she refers to in the next sentence as being the area to the rear, where there's a polytunnel where plants are grown for sale in the shop. So understanding what's meant by ground floor in the description of development read together with paragraph 4, it's clearly the ground floor of the building as opposed to the area to the rear. Now, reliance is placed on the fact that the inspector does refer to the area to the rear and refers to the fact that plants are grown for sale there. But that's because that was important for her consideration of whether to grant planning permission for the change of use of the ground floor of the building. We can see that from paragraph 6. This was an application that was not policy compliant in the sense that there was a policy that sought to resist the loss of retail units. And one of the justifications put forward by the applicant is that the existing use as a hardware store was not viable, and he'd been growing plants in the back in order to support its viability. Now that's relevant to the question of whether the ground floor of the building should cease to be in hardware store use. So that's why it's referred to at the beginning, because it's relevant to the question that the inspector had to ask, which is the change of use of the ground floor acceptable in planning terms? And that's also the answer to the reference to the garage and the parking area to the rear in paragraph 9. She's referring there to features that fall outside the scope of the permission, but which are relevant to her consideration of whether she should grant planning permission for a change of use of the ground floor. The fact that she's referred to the garage does not mean that she considered she was granting planning permission for the change of use of that garage. And that's shown by the fact that on anyone's case, the parking area to the rear fell outside the scope of the 2005 permission.
So does that mean that if the staff in the restaurant parked in the garage and walked through the garden into the kitchen, they're in breach of planning control?
No, not that they're in breach of planning control. I mean, that might be relevant to a question of whether the use has become immune under section 171B. But the garage had an existing use as a garage.
Well, it would have been ancillary to something.
And ancillary either to the shop or ancillary to the residential flat above, which also had access into the garden at this point.
Right, and if the kitchen staff put the rubbish out at the back, then what? Put the bins out behind where those doors open into the rear area? Is that allowed or not allowed?
Well, it would fall outside the scope of the permission, so it would not be allowed. But of course, this is not a restaurant that relies on that rear garden area. There's an access to and from the restaurant from the front. There's also separate access to the garage along the access road. So, and this links into the absurdity argument. No, standing back as a reasonable reader, one would not look at this permission and say, well, that cannot function as a restaurant unless it includes the garden area at all. So that's the answer to that. And that explains also why the inspector is referring to the garage and the parking area, because it's relevant to the considerations you have to take into account in deciding whether to grant planning permission on the ground floor. If I then turn next to the plans, starting with the site plan.
Yeah.
And if I can deal first of all with the case of Barnet, which you were taken to by my learned friend. The simple point is that the Barnet does not establish that the red line plan always demarks the geographic extent of a permission or a permission for a change of use. The simple proposition that Barnet is authority for is that where planning permission is granted for a new dwelling house, there is a rebuttable presumption that the red line on the site plan delineates the curtilage of the new house. That's what Barnet establishes. And the reason for that, and I'll take you to the reasoning of Lord Justice Keane in a second, but the reason for that is that it necessarily follows by implication that if you're erecting a new dwelling, and in particular a new detached dwelling, there will be within that an implicit application to use the land surrounding the building for the purposes of incidental uses. And that is why, where you have a granted planning permission for the erection of a new dwelling surrounded by a red line, there's a rebuttable presumption that the permission grants planning permission for that change of use. And we can see that from the judgment of Lord Justice Keane. So Barnett is at tab 12 of the authorities bundle. And the key passage is paragraph 29, which is on page 162. My lords, I know you've already seen this, but if I just give you one second to read it again.
Yes.
So that's the point. If you have a planning permission for the erection of a new dwelling, the reasonable reader would understand that that must bring with it an implicit application for a change of use. And then one looks to the red line plan to understand the extent of that. Lord Justice Keane then distinguished that from a situation where an application is made to extend an existing dwelling, because in that case, it can't necessarily be assumed that the application brings within it an application to change the size of the curtilage. And in that situation, you don't have a rebuttable presumption that the red line demarks the extent of the curtilage. Rather, you construe the permission as a whole, and we can see that from paragraph 30, the following paragraph. And the simple point here is, this is not a case where there was an obvious implication that the planning application to change the use of the ground floor brought with it an application to change a use of a wider area. For the reasons I've said, the ground floor could function as a restaurant without the use of the rear area. So a reasonable reader would not look at the description of development and say to themselves, as they would with a new detached dwelling, that the change of use of the ground floor must bring with it a wider change of use, and then look at the red line plan to ask themselves what that is.
Well, I mean, is that quite what Barnett decides? Barnett is deciding in paragraph 29 that if you apply for permission to construct a new dwelling on non-residential land, you are necessarily asking for a change of use.
Yeah.
And if you do that, then the area to be covered by the change of use will normally be that which is enclosed by the red line on the site plan.
Yeah.
If, on the other hand, you are extending an existing dwelling, you are not necessarily applying for a change of use.
Yeah.
You may or may not be.
Yeah.
And on the facts of Barnett, see paragraph 31, they weren't applying for a change of use.
Yeah.
Therefore, the principle that might have applied if there had been an application for a change of use did not apply, because it wasn't necessarily implicit in the application that there was such a request, and there was no express request. In our case, there is an express request for a change of use.
There is, but the scope of that is defined by the application itself, by the description of development. The question is whether one then has to say, well, the description of development says ground floor, does that encompass a wider area?
Yes.
In which case there's a rebuttable presumption that you look at the red line plan. And my point is we're not in that territory here.
Well, I'm not sure about that. I mean, aren't you really saying that if you go back to paragraph 29 of Barnett, that part of the site not built on can be used for purposes ancillary to the dwelling unless there is some obvious restriction shown on the permission itself?
Yeah.
Your point really is that there is an obvious restriction shown on the.
Well, yes.
It's restricted to the ground floor.
Yeah. I mean, I've got 2 points, I suppose. Point 1, Barnett, paragraph 29, establishes a rebuttable presumption. It can be rebutted here by looking at the description of development. But I do have another point, which is we're not actually in the circumstances that were taken into account at paragraph 29, because it's not obvious that the grant of planning permission for change of use to a restaurant brings within it a wider change of use of a wider area, in which case there's no rebuttable presumption at all. One just looks at the terms of the planning permission. Because, my Lord, Lords, it's also important to look at how the arguments were framed in Barnett. And in particular, paragraph 26 on page 161 records the submissions made by Newbury QC, refers to regulation 3, which is now in the Development Management Procedure Order. And the submission that was made 4 lines down is, the effect of that is that the planning permission subsequently granted then relates to the area of land shown on the site plan. That, he says, is the function and purpose of the site plan. That, he acknowledges, means that permission to alter the windows would also grant planning permission for ancillary residential use. But he submits that even when such a use is not specified on the permission itself, the change of use is implicit within the documents to which reference can be made. He contends that as a matter of principle, all land shown is included within the site plan on a site plan in a planning application, therefore receives the benefit of any resulting planning permission. So that was the principled argument that was made to the Court of Appeal in this case, which is then picked up at paragraph 30. Where Lord Justice Keane refers to the extreme example to which Mr. Newbury had to concede his argument led. So there's no general principle that the site plan delineates the extent of a change of use. And again, that's a principle that a reasonable reader of this permission would be aware. In certain cases, there is a rebuttable presumption that it would normally delineate an extent, and we say that presumption is rebutted here. And of course, that wasn't the only plan that was submitted with the application and approved by the inspector in granting planning permission, because we also have the proposed layout plan, which is at tab 3 of the supplementary bundle at page 20. And again, that is consistent with an interpretation of this permission that it applies to the ground floor of the building.
So what are the doors doing?
So there's there's the fire exit, and then there's the door from the kitchen.
Yeah.
They're providing access into the garden in the event of emergency, but the fact that there is access into the garden in the event of a fire doesn't mean that the permission extends to the garden.
Isn't it an indication that the garden will be used with the restaurant to some extent?
Well,
Either in event of emergency, fire, or simply because of deliveries to the kitchen or putting out the rubbish or whatever.
I have to accept it. It is an indication in favour of the appellant's interpretation. I can't contend otherwise. The question is it an indication of sufficient weight to say it cuts against what we say are quite clear words in the description of development, and we know what the inspector meant by them because she tells us. And the other point to make here is, consistent with that description, for a start, the layout plan doesn't extend into the garden. There's no marking showing what the garden might be proposed to be used for. And whilst we do have the first floor layout, that is only in order to make sense of what's happening on the ground floor. And it's the ground floor of the building itself which is labelled and marked up. Because, of course, for both of these plans, both the red line plan and the proposed layout plan, and going back to the rebuttable presumption in Barnett, one other factor which strongly rebuts the suggestion that the red line plan delineates the extent of the planning permission is that the red line plan covers both the ground floor and the first floor, when it's quite clear from the description of development that all that's been granted planning permission for is a change on the ground floor, and also nobody is suggesting that there was a change of use of the first floor flat from residential to a restaurant use. And the judge was right at paragraph 24 to rely on both those factors as an indication that the red line plan in this particular case does not delineate the geographic extent of the 2005 permission.
The judge doesn't seem to have considered the doors at the rear of the building, as far as I can see, what they might indicate.
They may not be referred to in terms, no.
And he doesn't seem to refer to what the inspector said about the garage being used for staff.
No, my understanding is the first time that point's been made, I'll be correct if I was wrong because I didn't appear below, but the first time that point's been made was today.
Right.
It hasn't been relied on before. The point about the doors going into the garden has been relied on by the appellant in the past, but not paragraph 9 of the decision letter. So that's the description of development, the approved plans, which we say certainly the layout plans are consistent with the description of development. If I can then deal with the conditions, and of course as a matter of principle, it's appropriate to interpret the scope of a permission having regard to the conditions. Now in this case, whilst the inspector, so this is the appeal decision, tab 6, page 25, the inspector clearly thought that a condition requiring sound installation would be necessary. Apparently in error, that wasn't then imposed on the actual permission itself. But nonetheless, I would submit that her reasoning at paragraph 8 can be taken into account in interpreting the scope of the permission. And in that respect, the judge was correct to identify that it is surprising that there is no consideration, or at least expressed consideration, regarding the potential noise that could be generated by the outside area and the impact on residents beyond just the flat above. So soundproofing was proposed for the benefit of the occupier of the first floor flat, but beyond that there's no consideration of potential noise impacts from the garden area. And again, that as part of the relevant factual background is relevant, we say, in interpreting the permission, and is consistent with the inspector considering that what she was granting planning permission for was the change of use of the ground floor of the building only.
Well, paragraph 8 is looking at conditions put forward by the council.
Yeah.
Paragraph 9 looks at neighbouring occupiers, and the only complaint there is traffic, not noise.
Yeah.
So noise wasn't an issue for the inspector, except insofar as the council was concerned about noise to the upstairs flat.
Well, noise, I mean, it appears from this that noise wasn't raised by neighbouring occupiers as part of their responses, and we would say that that is because they'd understood that permission was being granted for the change of use of the ground floor, and therefore noise in the outside area was not a consideration that they raised an objection.
Yeah.
But my point is the inspector also seems to have proceeded on that same basis too. It's entirely commonplace to have, for example, conditions which require an outdoor area to close earlier than the inside area. That is a commonplace condition that you would see on a planning permission, and it's not in effect here, and there's no consideration of that by the inspector. All of which is at a piece with our interpretation and the judge's interpretation of the permission. And then I can finally deal with the absurdity argument, which is in effect, recourse to common sense in interpreting the permission, which is a factor that obviously the court can take into account if a particular interpretation leads to a nonsensical outcome. The reasonable reader would not interpret the permission in that way. But there's nothing nonsensical about the interpretation put forward by the judge. As I've said, the permission would grant consent for a functioning restaurant with all the features necessary for it to operate. Not a case where permission's been granted for a restaurant use and there's a debate about whether that permission should extend to the entranceway or whether it includes a kitchen. If permission was granted from a restaurant that was landlocked, then that might be a factor that you can take into account. There's nothing absurd about having a restaurant without an outside area to the rear. And in terms of the fact that this severs the ground floor from the garden to the rear, there may be all sorts of reasons why the applicant chose to apply for planning permission for a change of use of the ground floor of the building only. For a start, as I've said, this is an application that was already not policy compliant because it was going against the development plan policy, which sought to resist the loss of retail units. Now, we don't know, but the applicant may well have taken the view that extending that proposed restaurant use into the garden would bring with it all sorts of amenity concerns and considerations of the type that we're talking about today. The applicant may also have taken the decision that actually there was no need for that outdoor area. As I said, the restaurant functions without it. The applicant did not intend to have an outside seating area, and therefore the permission wouldn't extend to that area. We simply don't know, but the point is that the reasonable reader looking at this permission would not say, well, that's absurd, that cannot be the case. Because there's all sorts of reasons why a choice may have been made to apply for planning permission in this way.
So what, after the grant of this permission, was the lawful use of the garden?
Well, the lawful use of the garden, I mean, that depends on what the lawful use of the garden was prior to the grant of the permission.
Well, it seems to have been in use as ancillary to the shop.
Well,
Isn't it? For growing plants to be sold in the shop.
Yeah, that does, well, certainly seems to be the case from the inspector's decision. But there was also access into the garden from the flat above. So it may well be the case that it was used.
Is that right? Do we know that?
That is right. That was the position.
Where do we get that from?
I'd understood that was that's certainly. Well, I'd have to find the reference. I'd certainly understood that to be the position.
Well, we're told that the kitchen of the flat is on the ground floor.
So the
And
kitchen.
there was a self-contained entrance. And then we're told that at the rear, there's a polytunnel where plants are grown. I don't think it says anything about access by the flat.
Well, there's certainly there's an entrance into the flat. So, my lord, if we look at tab 3, page 20.
Well, this is page 3 is what's being proposed, isn't it? And the entrance to the upper floor shown on page 3 is the entrance from the street.
Yeah. But my understanding of the position prior to so this shows the proposed layout. My understanding of the existing layout was that you had an entrance to the flat from the street, and that corridor, which then continues behind the staircase, continued on so that where the toilet area is now, that was previously the kitchen to the flat above, because of course the kitchen was relocated from the ground floor to the first floor, and the only place that the kitchen could have been on the ground floor was in that location. So
when did that relocation?
That was granted in the 2005 permission. So
after the 2005 permission, there was no access to the garden.
That's absolutely right. But in terms of the position in 2005 when the permission was granted, my understanding was that the permission.
Well, let's suppose that your understanding is correct. What was the lawful use of the garden after the grant of the 2005 permission?
Well, it remains whatever it was prior to the permission. Then the 2008 planning permission.
What, either shop or garden?
Either shop or garden, yeah. Yeah. And then the 2008 planning permission is granted. That is a temporary permission for 1 year. At the end of that permission, the use permitted by it, i.e. a mixed A3, A5 use, is required to discontinue. So we can see that tab 10, page 44.
Yeah.
So we have a position where up until February, between the grant of this permission in February 2008 and February 2009, the lawful use of the garden includes...
Just remind me, A3 and A5, that was, one of them was just restaurant, the other one's hot food for takeaway. is it?
Takeaway, yeah. So A5's takeaway.
Yeah. And so that definitely includes the garden, because
Yes.
they're telling people to park.
Yes, it does.
They do deal with soundproofing, but only internally generated noise within the building.
Yeah.
They're not concerned about noise from the motorbikes or whatever it is, the road riders.
Yeah.
Um,
But my lord, to answer your question, when this permission expires,
we go back to whatever it was before.
well, no, you don't. So the effect of the condition is that the use hereby permitted should be discontinued. Planning permission is not required to go back to the use before. But that doesn't mean that that becomes the use. It just means that you don't need planning permission to go back to where you were before. So in terms of the use after February 2009, that depends on what the garden was being used for. Whether that use is lawful or not depends on what the garden's been used for. I can't answer these questions because these are questions that we say should have been asked by the officers before reaching a judgment on what the lawful use of the garden was.
Yeah.
It's not the role for us or the court to answer that question of what was the lawful use of the garden after 2005 permission, because it depends on all sorts of things, how it was used before, how it was used on the ground between the grant of permission and the 2008 permission, and then what happened after the 2008 permission lapsed or expired in February 2009. How was the garden actually used? And that will answer the question of what the lawful use of the garden was.
Yeah.
My lord, I'm perhaps slightly jumping ahead, but that's the answer to the suggestion that Class E applies regardless of the correct interpretation of the 2005 permission, because Class E would only apply if the garden was actually being used for a purpose falling within Class E1A. And we can see that in the authorities bundle at tab 3, page 34. So the point being made...
Sorry, just a minute, I'm
Sorry.
behind you.
Tab, sorry, please. The tab again. Tab.
my lord, it's tab 3, page 34.
Well, may I just rise to assist on the point of fact that you were asking about the location of the door? My learned friend is right, I've taken instructions. There was a door from that kitchen,
Thank you.
which I hadn't understood.
Thank you.
Lord, so this is Class E, and the argument that's put forward, although not by the officer, but put forward as part of these proceedings, is that, well, even if the 2005 permission didn't extend to the garden, its use can only have been for the display or retail sale of goods, given the history of how the garden had been used previously, and one can move from Class EA to EB without the need for planning permission on the basis it doesn't amount to development. But if one goes back to Article 3 of the use classes order on page 32. Article 3.1, subject to the provisions of this order, where a building or other land is used for a purpose of any class specified in the schedule, the use of that building or that other land for any other purpose in the same class shall not be taken to involve development of the land. So if one goes to the situation in February 2009, the 2008 permission has ceased. Condition 1 on that permission says the use permitted by that permission should be discontinued, i.e. the mixed A3, A5 use. Class E would only apply if the garden was then used for a purpose falling within Class EA, because it only applies where the garden is actually in use. And it doesn't appear that that's the case, but in any event, that's the sort of consideration that would be necessary for a planning officer to investigate and determine for themselves. But that's the answer, the simple answer to the Class E point. And the same answer can be made in relation to the reliance on section 171B. Because there is simply no consideration in the officer's report of the types of questions that would need to be asked in order to reach a view that the use had become immune from enforcement. My lord, in terms of the test that needs to be asked, it's set out in the Ocado judgment. So it's in the Authorities Bundle, tab 21, page 349, paragraphs 51 to 58. There, Mr. Justice Holgate goes through the case law.
Which paragraph?
It's page 349.
Yep.
And it's a series of passages that starts off, it's paragraphs 51 through to 58. But we could probably just skip to 58, which summarises the cases of Thurrock, Moylan and North Devon. What needs to be shown is that throughout the 10-year period, the local planning authority would have been able or entitled to take enforcement action. In other words, the unlawful use needs to be continuous throughout the 10-year period, to the extent that at any point the council could have gone along and said this is an unlawful use of the land. And that clearly requires some consideration of how that garden was actually used from February 2009, which is when the temporary 2008 permission expired, to February 2019. Now, whilst the officers visited the site in considering the application for the pergola, and whilst they would have looked at the planning history and the approved plans on the planning permissions, there is no evidence at all, and nor, as I understand it, is it suggested that officers asked themselves that question of how was this garden actually, as a matter of fact, used in that period. And that is the essential reasoning of the judge below, that this argument on reliance section 171B doesn't arise on the facts, because it required a determination to have been made that wasn't in fact made.
Yeah. Yeah. Right.
And then finally, can I deal with the question of the planning unit and its relevance in all of this? Because, of course, the planning unit is a creature of the courts, but its function is to determine the geographic scope against which you measure whether a particular change is a material change of use or not. So that's its function. And we can see that, my lords, I don't ask you to take it up, but you can see that summary in the Encyclopedia of Planning Law, which we have at tab 26 of the bundle. That's its purpose, to identify the area against which you measure whether a particular change of use is material or not. And so that's internal page 32 of tab 26.
Sorry, internal page.
32. So that's what the planning unit is. And of course, it's perfectly possible to apply for planning permission for a change of use of part of a planning unit. There's no obvious connection between the planning unit, which is basically a unit of measurement to determine whether a particular change of use is material or not, and the scope of a planning permission. So the simple answer to the planning unit points is, well, so what? Even if the ground floor and the garden formed one planning unit prior to the grant of the 2005 permission, or even if they didn't, it doesn't tell you anything about the scope of the 2005 permission, which one interprets by reading it as a reasonable reader would. A reasonable reader wouldn't scurry around trying to determine the extent of the planning unit. They'd look at the words, they'd look at the plans, they'd ask themselves, does this make sense? And that's the scope of the permission. So the planning unit is a complete red herring in this case, because the fundamental test is, what would a reasonable reader of that appeal decision understand that planning permission had been granted for? But in any event, I do support the reasoning of the judge, which is there is no consideration, even if it is relevant. It's not a question which officers appear to have directed their minds to in the officer's report. But the simple point is it doesn't matter. So, my lord, that's the 2005 permission, the alternative routes to enforcement, and the relevance of the planning unit. Well, if you could just give me a minute just to double check that I've covered everything I wanted to on those topics before moving on to the respondent's notice points. My lord, I should probably just deal with the suggestion that the judge applied the wrong test and considered that the question of whether a use was immune from enforcement under section 171B was a matter of law for the court. And he deals with that in his judgment. So this is tab 10. The core bundle, and it's paragraphs 20 and 21.
Yeah.
In paragraph 20, he summarises the arguments that were made. First, that the use of the garden as a restaurant was lawful as a result of the grant of the 2005 permission. And secondly, the council argues that the question whether the use was long-standing and lawful was a matter of fact and degree and a pure matter of planning judgment for the council, and so not amenable to challenge in this court. And rightly or wrongly, the judge appears to have interpreted the second argument as encompassing within it a suggestion that the correct interpretation of the 2005 permission was a matter of judgment, which is why he goes on to say, I deal with the second argument first, as I must, because if correct, it nullifies consideration of the first.
Well, I'm not sure he does, but he puts it in what I described earlier as very absolutist terms, which can't be right.
Well,
whether an admitted use is or would be lawful is not a matter of planning judgment. It is a matter of law in the jurisdiction of the court. That can't be right, put like that, can it?
Well, the sentence before that says, I accept whether a use is long-standing as a matter of assessment. Now, I read long-standing there to encompass within it a reference to section 171B. And that is a matter of assessment, and that is a matter of ultimately fact, degree and judgment for the council, subject only to review on Wednesbury grounds. Then it goes on to consider other routes to lawfulness, and he's correct that he's dealing here with a situation, first of all, where the grant of planning permission is subject to a planning permission, and in that case it is a matter of law for the court, or where permissions granted in reliance on the provisions relating to permitted development, which come from statute and
May or may not be a question for the court.
may or may not, depending on what the issue is. If the issue is how you interpret the permitted development order, it is. If it's how it applies to the facts of a particular case, it's not. I mean, what's clear, I would submit, is that even if perhaps this paragraph could have been phrased differently, it hasn't actually affected the judge's essential reasoning, because he was right to interpret the 2005 permission as being a legal question. And when he goes on to Class C in section 171B, his point is, well, the council hasn't asked the questions that they needed to ask. And that's also, my lord, very clear from his reasons for refusing permission to appeal below, which are on the next page, page 95. And if I ask you in particular to read paragraph 4 of that.
Yes.
So, unless there's anything else I can assist with on those points, I propose to turn to the respondent's notice points.
All right, thank you.
So, and can I start off with issue 2 in the respondent's notice? So, this is that even if the rear garden could lawfully be used as a restaurant, so we've lost on every single point that I've been making submissions on so far, it does not follow that additional noise issues associated with the pergola were not material to the decision on whether to grant planning permission for that development. And I've got 2 essential submissions. First, the council did proceed on the basis that because the garden had a lawful restaurant use, it was not possible to refuse to grant planning permission on the basis of the noise associated with the pergola. And second, that if that is the approach taken, it's clearly wrong in law, because even if a restaurant use of the garden was lawful, the operational development associated with the erection of the pergola had the potential to facilitate noise disturbance in the rear garden that would not otherwise arise. And the council erred in concluding that those impacts were not capable of being material. So if I deal with the first point first, and start off with the officer's report dealing with the first application, which is tab 11 of the supplementary bundle. And the starting point is page 51 under the heading Preamble/Background. And the officer states in wording that's then replicated in the officer's report under challenge that the use of the rear garden by customers is not restricted by planning condition and is not in breach of planning control, given the long-standing lawful use of the premises as a restaurant. The officer then goes on to consider design, first of all, as issue 1, and then neighbour amenity as issue 2. And under neighbour amenity, there's separate consideration of noise, so this is halfway down. And the first thing that's said is that the application does not include any form of acoustic assessment, and therefore it cannot be determined if the proposals would lead to an unacceptable loss of amenity to adjoining properties or not. There were also concerns over the proximity of the adjoining gardens, which are used solely for residential purposes. So pausing there is at least the potential for the pergola, for which planning permission is being sought, to give rise to an unacceptable noise impact. The report then goes on to say the commercial use of this rear garden is lawful in planning terms, and associated noise connected with this land use, whether open or enclosed must be a reference to the pergola, cannot, not should not, cannot be raised as a material reason for refusal in this case. In other words, the officer is saying that noise from the pergola cannot be a reason for refusal, even if it would give rise to an unacceptable loss of amenity, because the garden has a lawful restaurant use. And that's then reflected in the decision that's made on the application, because the recommendation on page 53 includes within it the statement at the end that it's unclear whether the scale of noise disturbance, on the adjoining neighbours, and if this will lead to an unacceptable loss of amenity. That recommendation is signed off by the team leader on page 54. So the report's written by a case officer, it's then signed off by the team leader. The actual reason for refusal on tab 12, page 58, does not include a reason for refusal in relation to noise. Now that is entirely consistent with officers taking the view that it cannot be raised as a reason for refusal. I mean, that's what they've said. Noise from the pergola cannot be raised as a material reason for refusal. That explains why we have a situation where officers saying, well, there may be a potential for a significant noise disturbance here, but then the reason for refusal itself doesn't reflect that. They took the approach that they could not consider that. And I would submit that the same approach is then taken in the officer's report for the application under challenge. So, sticking in the supplementary bundle, tab 17, page 93. Noise is addressed at page 93, and there's no suggestion.
Sorry, just a minute. I've been working off the version in the core bundle, so let me get to the right page. Yeah, page 229, core bundle. Yeah,
229. So it's 4 paragraphs down. There's a paragraph that starts, and this is the key paragraph for the use of the rear garden by customers is not restricted by planning condition and is not in breach of planning control, given the long-standing lawful use of the premises as a restaurant, same wording as the first officer's report. Consequently, i.e., as a result of that, issues associated with this use, such as noise or parking, are not in question. And it goes on to refer to mitigation of noise disturbance being dealt with by existing planning conditions and any breaches of those conditions being dealt with separately to this application. Now, in terms of what is meant by are not in question, reading these two reports together, I would submit that that is exactly what's meant by that, is what was meant by that in the first officer's report. Noise impacts derived from the pergola cannot be raised as material reason for refusal. Because in relation to noise, nothing had changed between the first officer's report and the second officer's report. There was no new acoustic assessment put in. There are no measures proposed in relation to soundproofing or anything that could have changed the analysis in relation to noise. So one has to assume that officers have taken the same approach. In relation to, there is a reference, what's different between the second report and the first is the reference to existing planning conditions. That's not in the first.
Sorry, is it reference to?
Existing planning conditions. So this, if we're in the second report,
Yeah.
after officers have said are not in question, it then goes on to say mitigation of noise disturbance is
Oh, I
secured.
see.
Yeah. Now that isn't in the first report. It is in the second report. And it goes on to say any breaches of conditions such as operating hours of the business should be dealt with separately to this application. But those conditions can only be the conditions attached to the 2005 permission,
Operating hours of the restaurant.
operating hours of the restaurant, and are dealing with a situation where the garden can only be used for seasonal use, not dealing with a situation which would arise were planning permission to be granted for the pergola, where the garden could be used year round. We say it's reading a lot into that sentence, mitigation of noise disturbance is secured by existing planning conditions, to say that in that sentence, the officer is dealing with the potential noise impacts from the pergola, the extent to which that may give rise to additional noise impacts that wouldn't arise were the pergola not to be there, and reaching a conclusion that those impacts are acceptable because they would be addressed by the conditions attached to the 2005 permission. That's reading a lot into that one sentence. What is happening here is one has to read that sentence together with the next sentence. Mitigation of noise disturbance is secured by existing planning conditions. Any breaches of conditions, such as operating hours, should be dealt with separately to this application. And that is because one of the comments that was made by objectors to this application is that the applicant was regularly breaching the existing conditions attached to the 2005 permission. So we can see that, for example, if we go to...
Yeah, page 228, the last of the objections.
Yes, I was going to go to the objection itself.
Oh, right.
But if it's... Yeah, but it's actually, my lord, as you say, it's summarised in the report. And all that's been said here, quite rightly, is that if there are breaches of existing conditions, that's a matter that's separate to consideration here, because breaches of those conditions should be dealt with separately by way of the council taking enforcement action for breach of the conditions. It's not saying that those conditions are sufficient to address the noise impacts arising from the pergola. So that is the approach that was taken. Because the use is lawful, the noise impacts from the pergola itself are, as the officer put it, not in question. Or in the first report, cannot be a material reason for refusal. And that is an approach that's wrong in law, because of course operational development can, as a matter of common sense, can materially affect the nature of activities that can be carried out on a site, even if that change isn't sufficient to give rise to a material change of use. And in particular, the pergola here facilitated a year-round use, and it also facilitated the introduction of large-scale events, like wedding receptions, that could book out the entire pergola, which also has separate access to the rear, whilst allowing the existing restaurant in the building to operate as usual. And that was one of the points that was made by the objectors, that the pergola, as well as allowing year-round as opposed to seasonal use, results in the introduction of commercial events in the garden, which otherwise wouldn't have been able to use the garden for that purpose. So both of those points were capable of being material. The impacts associated with that change in the character of the use were capable of being material consideration. And if you're with us, that the officer closed their mind to those considerations on the basis that the existing use was lawful, then the report is significantly misleading. And if I can then deal with...
Are we into reports being misleading territory? This was an officer's decision. I mean,
Well,
you're not saying he misled himself, are you?
Well, strictly speaking, it's a The report is written by the case officer to the team leader, who is the actual decision maker. So the Mansell tests apply
see.
apply just as much in the case of delegated decisions, but it is, I agree, somewhat artificial. It's an error of law, is the way I would put it, regardless of whether it's significantly misleading or not. And then if I can deal briefly with the three main points put against me. First, it said, well, noise was taken into account as a material consideration. Look at the reference to the policy, look at the reference to noise in the report. And of course, it's true that the topic of noise was considered, but obviously the respondent's complaint here is more fine-tuned than that. It's not that the officer completely failed to consider the potential for noise impacts. It's that having turned their mind to that topic, they erroneously took the view that they couldn't take into account the potential for noise disturbance as a material consideration because of the lawful use of the land. So noise as a topic is obviously dealt with, but how it was approached was erroneous. Secondly, it said that the assessment of the impacts of noise is a matter of planning judgment. Well, that is, of course, correct. And had the council taken the potential for increased noise into account and reached a view that the pergola would not increase the level or frequency of noise compared to the existing position, or that any increase would be acceptable, then obviously I'd have no legal leg to stand on here. But that's not the approach taken. And we know that's not the approach taken because officers have told us that there is the potential for an unacceptable impact on residential amenity as a result of noise here.
I don't think we actually see that in the report of this decision.
No, we don't.
No.
Yeah, no, we don't. That's in the first report, but nothing had changed in terms of the design of the development. Nothing had changed in terms of evidence that had come in from the applicant to lead to a different conclusion there. Which is why I say they must have approached it in the same way the second time as they did the first, albeit that the language is slightly different. The essential reasoning is the same. And then thirdly, it said it's not surprising that there isn't more consideration of the potential for increased disturbance in the officer's report, because it's not a point that the respondents made in their objection. This suggestion that the character of the noise would change as a result of the pergola. And that's just not correct. We have the comments made by the respondent's wife. They're at tab 16 of the supplementary bundle. Page 87. She directly refers to the appeal inspector's comments that the effect of granting permission would be to create a permanent large enclosed structure to facilitate year-round usage by restaurant guests on this mixed-use site. Now, regardless of whether the inspector...
Sorry, where are you?
It's page 87.
Yeah.
Point 4 at the bottom.
Oh, yes.
Yeah. She says the council should take note of the...
Yes.
Yeah. Now, regardless, and I'll probably deal with this after lunch, regardless of whether the appeal inspector is talking about noise or not in the appeal decision, this objection is clearly linking that comment to amenity impacts. She says, the proposal will have severe negative impact on my family's use of garden and privacy, serious concerns regarding overlocking, loss of privacy, noise and light disturbance, and increased traffic and use of the site. And then goes on to say, in that context, that what the inspector says about facilitating a year-round usage is something that the council should take into account. And then finally, on this, just over the page, this is the point about the pergola permitting a different type of customer on the site, i.e. permitting wedding receptions and the like. She goes on to say, the pergola covers the entirety of the property's back garden. It converts a private outdoor space to an indoor commercial use in stark contrast to the neighbouring gardens which maintain residential use and landscaping. So that change in the character of how the outdoor area could be used was directly before officers.
Sorry, you referred to paragraph 3, which refers to noise and light.
Noise, light, and increased traffic and use, but noise and light in particular.
Yes.
And I don't know if that's a convenient place to pause, because I was then going to move on to the inconsistency point.
What do you say to Mr. Streeton's point that in fact the officer did consider the question of noise, because he was satisfied that the proposed development complied with policy LP8?
Well, we simply don't.
You don't need to deal with it right now, but you will have to deal with it.
Yeah. That a judgment was reached that the
Yeah.
additional noise
Yes,
was acceptable.
he says, well, that was for the officer to consider as a matter of planning judgment.
Yeah.
He satisfied himself that the development proposed complied with policy LP8. That's his judgment. There you are. That's it.
Yeah, well, I'll deal with it further after lunch, but the answer is twofold. Firstly, we don't see the reasoning for
Yeah.
that,
All right.
which gives,
Yeah.
and secondly, we say that actually that judgment wasn't reached because that's not what the officers are saying in these reports.
Right. So it sounds as though you haven't got much more than half an hour.
No.
Mr. Streeton, I doubt you're going to be more than half an hour in reply. So we'll finish, well, very comfortably this afternoon. All right, well, I'll say 2 o'clock in that case. You can have an extra 5 minutes for lunch.
Court rise if able.